Hello aspirants, welcome to Rankers Academy. Today's topic is Article 142 and as I promised you people, I'll come up with confusing topics but make it simple for you. So now let's start. So why Article 142? So this article is basically discretionary power of Supreme Court. So what is the meaning of discretionary? Discretionary is exclusive power of Supreme Court, and even Supreme Court is not bounded by any external pressure or any external influence, and it will use this article whenever it feels like. So that is a basically meaning of discretion. So now why this article was in news? Basically what happened, this guy AG perarivalan, he is the one, he was a convict in Rajiv Gandhi's assassination case and he was set free when Supreme Court has invoked this article. And this article 142 of the Constitution, this was invoked in this particular case. So now actually the definition of this article, what does this article talk about? This article is actually when Supreme Court wants to do complete justice in any particular case or any matter which is pending before it or anywhere where it thinks that justice has not been done. In that case, this article 142 is used and it is a discretionary power of the Supreme Court. Okay, so why Supreme Court has actually invoked this article in this particular case? So that is something which we have to think, right? Because that guy, he is actually convict in Rajiv Gandhi's assassination case, and why it has to use a discretionary power to set him free. So now let's start with the case. So firstly, this Pedri 11 guy, he was 19 years old in 1991 when Gandhi was killed, and at that point of time this guy has supplied batteries which were used in the bomb to assassinate the Prime Minister, and he was sentenced to death by Tada court in 1998, and this Tada is right now it is repealed. Okay, and now actually what happened, and in 2000 these people, he and others who were actually convicted in PM's assassination case, these people have sent mercy petitions to president, but that time president did not respond. It went on, it was delayed for years and years, and for 11 years it was almost delayed. And when Pratibha Patil, when she was the president in August 11 2011, she completely rejected these mercy petitions which were pending with the president for 11 years. And then at that point of time, this Perry Revlin and other convicts, death convicts, they were supposed to be hanged in 2011, but Madras High Court has stayed the execution of these orders. And even that time, Jayalalitha, late Jayalalitha, the Chief Minister of Tamil Nadu, even she actually seeked for the commutation of the death sentence of these convicts. So now, again from 2011 till 2013, when the case came into hearing, at this point of time, there was a new concept called double jeopardy has come into limelight. So double jeopardy, what is double jeopardy? All of you must be aware. So anyways, I'll tell a brief thing about double jeopardy. It is under Article 20, where a person cannot be convicted twice for one crime convicted, right? So actually this was what came into limelight in 2013, and this was basically came into limelight because KT Thomas, this he was a justice at that point of time of Supreme Court. He was one of the judges of Supreme Court, and he said that a to actually hang these people after 23 years of serving in prison is completely unconstitutional. Basically 14 years is the minimum thing for a person to be sentenced for life sentence. Then it is 20 years, 25 years, and even a person can be sentenced for whole life. So here these people have served 23 years. It means almost they have served one life sentence. And again you are actually giving them a death sentence. So here the people are being punished twice. So that is the reason two times a person cannot be punished for one crime convicted from one crime committed. So that is the reason why double jeopardy has come into limelight. So at that point of time, even actually what happened was there was a former CBI person, he was a Tyagarajan. He said that this guy Perry Levelan, and he didn't know that this battery was used in the bomb to assassinate the Prime Minister, and we forcefully made him confess saying that he knew. So that is the reason in 2014 Supreme Court has actually committed the death sentence of the 3 Rajiv Gandhi convicts. That is, even this Perliavan guy was there, and even 12 others, and even that Veerappan was also there, to life imprisonment. And then from this point of time, from 2015, this Perliavan guy, he submitted a mercy petition to Tamil Nadu governor under Article 161. Now, 161 is the article which actually pardoning power of the governor. And at this point of time, the governor did not respond. He kept on delaying this mercy petition which was submitted by perarivalan. Then in August 2017, Tamil Nadu government, he granted parole to perarivalan. Parole is different from bail. Parole is granted for 1 month on the promise of good behavior to a prisoner, and then he has to be again brought into jail. But this fellow was given parole by government. They kept on giving parole for days and days, months and months. So that is the reason why he was out. And at this point of time, and also what happened in 2021, Supreme Court has actually asked the governor. He asked him that why he's not giving any kind of decision regarding the mercy petition submitted by perarivalan. And it even told the governor that if he won't take any kind of decision, then it will be forced to release these people because of inordinate delay. At this point of time, what this governor did is he sent this mercy petition to president. Even president did not respond. Even he kept it with him. So it went on. Then what happened at this point of time? This article 142 was invoked, and on May 18, this guy Perlian was set free. So why did this article was invoked is basically what happened, as Supreme Court told the governor that it won't, if governor does not take any action, then in that case Supreme Court will act and will let this guy free. So this is what it has done by using this article 142, which actually gives extraordinary power to the Supreme Court to do complete justice. And actually at this point of time, what happened was, Center has argued saying that it is the president's exclusive power regarding pardoning of a person who is convicted and who was actually given a death penalty. But Supreme Court said no, it's not like that. Even governor has the power to pardon. If at all we say it is exclusive power of the president, then whatever governor has done so far will become redundant. And even the article 161, which is the pardoning power of the governor, will be completely like a dead letter. So whatever the governor has used in past 70 years for the pardoning of people, for actually pardoning of people who are convicted for death sentence, will be completely invalid, rendered invalid. So now you people must be wondering, thinking, why death sentence? It is exclusive power of president, right? Yeah, there is a difference for that. The reason, firstly, president's pardoning power is different from governor's pardoning power. So what is the president's pardoning power is, if at all president pardons a person who is convicted for a death sentence, that person is completely acquitted, that is, he'll be released. But whereas the governor, if at all he pardons a person, that the person cannot be released as such, but the death sentence can be commuted to life sentence or other lesser punishment. And later, after that, later next time, the second instance, then governor can set him free. So two things have to happen when it comes to governor pardoning a person who is convicted for a death sentence, unlike a president who is pardoning a person for a death sentence. So what is the jurisdiction of the president for death sentence? So under articles 172 the constitution, it gives the president power to pardon the persons who have been tried or convicted for any offences, and the persons any offences against the union law. In that case, the exclusive power is with the president. Even state laws also, but usually state laws are done with governor, done by governor. Any offense against the state law is usually, the pardoning power is basically done by the governor. And next, when it comes to the martial courts, any sentence given by martial court, it is exclusive power of the president, no, not governor. Governor does not have any role regarding this. And when it is a death sentence, these are the cases when governor actually uses the pardoning power. So what are the features of the pardoning power of the president? So this is independent of the judiciary. What is the meaning of independent of the judiciary? Independent of the judiciary means So this pardoning power of the president is not part of judiciary thing. So it is completely independent of judiciary. So separated from judiciary, right? And basically it's an executive power. This is not a judicial power. This is actually an executive power. That is, here the executive is basically, it is using this power. Executive is actually using this power to pardon a person, and it is not a court of appeal, like the way, for example, if anything we keep appealing, like from high court it goes to supreme court, or from district court it goes to high court, like the way appeal, it is not like a way of appeal. Basically, why this pardoning power was given to the president? The reason was to correct any judicial errors, to correct any judicial errors. That is, any man, humans are will tend to make any mistakes, or any time, like if any kind of mistake is done by judiciary or anything, to correct any kind of judicial errors, this pardoning, to correct those judicial errors only, this pardoning power was given to the president. Okay, so what are the pardoning power of the president? First is pardon, that is, it will completely remove both the sentences and the conviction, and it will completely acquaint him from all the sentences or punishments, and he'll be acquainted free. That is, he'll be let free. He can be released. So commutation is from harder punishment when it is given to a lighter punishment. For example, if a death sentence is commuted to a rigorous imprisonment or simple imprisonment, that is called commutation. So remission means reducing the period. Like for example, if a person has to serve 2 years, then the person will be asked to serve only 1 year. That is reduced. Remission means reduced. So respite is basically, it was given in special case, where basically because of physical ability, or because if a woman convict is pregnant or something, in that cases this respite, this pardoning power called respite is used. And next, reprieve. What is reprieve? Reprieve is basically, here they actually stop the execution of a death sentence, especially for some temporary period, so that the person will have a time to seek pardon or commutation from the president. That is the reason this reprieve is used. Okay, these are the powers of the president. So now we'll compare the president and governor's pardoning powers. As I told you people, that even president can pardon, deprive, respite, remit, suspend or commute, and even governor also, but he is exclusively for the offences against the state law. He is exclusive for the offences against the central law. But even president can do for the state law as well, but usually governor does. Okay, and he is the only authority to pardon death sentence. Yes, he is the only authority to pardon death sentence, because if he pardons a person who was given a death sentence, that person will be completely acquitted free. So, but when it comes to governor, as I told you people, that person will not be released or completely set free. Instead, that person's life sentence can be committed to a death sentence can be committed to a life sentence, or it can be stayed for some time. So that is the main thing what happens with the governor thing. So when it comes to court martial, exclusive power is president. When it comes to court martial, governor does not have any kind. So this article 142 was invoked previously also, not just in this one particular case. So in the cases where it was invoked previously was, firstly, like regarding cleansing of Taj Mahal. The Taj Mahal was becoming yellow because of industries nearby which were actually polluting the river, polluting the air, due to which Taj Mahal was becoming yellow, and where Supreme Court has imposed restrictions on the industries. And then this is how the Taj Mahal right now, it restored its beauty. And now next is regarding justice. To many under trials were given justice because when this article 142 was invoked. The meaning of under trial is a person who is not tried. What is the meaning of not tried? Not tried means this person under trial. For example, if a guy or girl, whoever is an under trial, he has actually done a crime called, like he's actually convicted for theft. So, for example, imprisonment for theft is 2 years, because his case or her case did not come into hearing. That fellow or that fellow is serving in jail for 5 years. So it means, because it did not come into hearing, this person was undergoing punishment for more than what he deserved. So in this case, Supreme Court has invoked this Article 142 and it actually acquitted all these under trials. So actually the reason is, anyways, all of us are aware that Supreme Court, High Court and even District Court all are actually burdened with heavy cases, due to which many cases are not coming into hearing soon. It is taking a long time, that is pendency time is very long. So reason of, because of which under trials were actually suffering due to this pendency of cases. So now next is Union Carbide case also, where the Supreme Court has actually invoked this article, and it actually, due to which the compensation was given to the victims of Gopal gas tragedy. And even in this coal block allocation case also, Supreme Court has used this Article 142, and due to which it cancelled many allocations of coal blocks which were given to people who were doing wrong. And also Supreme Court has invoked this article in 2016 and it banned liquor sale on highways. So because of liquor which was being sold in highways, due to which many accidents were taking place and many people were losing lives, due to which the Supreme Court has invoked this article 142, and it banned liquor on highways. And this article was recently used in 2020 also, that for Manipur cabinet minister, this guy T Shyam Kumar, he was actually facing disqualification for defection, but this speaker did not take any decision, and he kept on delaying his decision of suspending this person T Shyam Kumar. In that case, Supreme Court has intervened and he actually disqualified this person, because against the petition which was pending with the speaker. So these are the cases where Article 142 was used previously. So now we have learned about Article 142. So is Article 142 is something Supreme Court is doing good, everything is going fine. So what is it basically? So but it is a case of judicial overreach. That is basically judiciary is interfering in the executive sphere. See, obviously ban on the sale of alcohol in highways, national highways or state highways, it is a duty of central government where it has to make a law to ban. But here the Supreme Court it has invoked this discretionary power, it exclusive power, it did a justice, but it has actually overlapped with the uh, executive power. But we in our constitution we follow the doctrine of separation of power, and but even doctrine of separation of power is also basic structure of our constitution. But still Supreme Court has invoked this article and it said that no, we are doing justice for the people who are not actually being given a kind of justice in from executive sphere. And also cases of judicial overreach. This is a case of this Article 142, when it comes to invoking this Article 142, it needs to be regulated, because this is actually being a extreme case of judicial activism, that is over interference of executive sphere by judiciary. So that is the reason why this article need to be regulated by strict guidelines. And when it comes to invoking this Article 142 also, it needs to be referred to a constitutional bench of at least 5 judges. And also when this article is invoked in any particular case or any particular thing, in that case after 6 months whatever happens because of the judgment, that is negatives as well as positives, need to be taken into consideration and white paper need to be given. So this is what we have to do regarding using this article 142, and it needs to be used precisely. Okay, hope I made myself clear. If people have any kind of doubts regarding this article 142, you people are free to write in comments. We'll answer very soon and we'll give you people with good explanation. Now a brainstorming question for you all. So now you people answer me and tell me in the comment section this question and its answer. It's a very simple question. Anyways, I hope I made this topic clear for you all. Thank you, and please subscribe our channel for more updates, and we'll come back with new topics and will make you people aware of many things which you people would have find it very difficult when reading this topics in polity. Okay, thank you all.